Let's go back into the courtroom and get back to the heart of the matter here, which is about whether or not the prosecution can oversee this case based on the fact that one of their daughters was at the university that day. Watch.
So that was, I was asking you about that in the context of whether or not the adult child of one of your prosecutors had been interviewed or not interviewed at the direction of your office, right?
Yes, I think I understand what you're saying.
Okay. So subsequent to the hearing on January 16th, that adult child was interviewed by SBI, correct?
Not to my knowledge.
Okay. As you sit here today, you have no knowledge whether that adult child sat for an interview on January 21st with the State Bureau of Investigation at a highway patrol facility in Orem?
I'm not aware of that.
And so then you haven't seen the reports generated from that interview?
No.
You haven't listened to the audio recording of that interview?
No.
Nobody told you that that interview was going to happen?
No. Not that I can remember. That's completely...
Okay, well, I'll represent to you that it was 5 days after the hearing on January 21st. Does that refresh your recollection at all?
Oh, are you talking about after the hearing? I'm aware of that, yes.
Okay, and how did that come to be? Because you testified that your office has no involvement in the investigation.
Well, it was a point that you had pointed out, and so out of an abundance of caution, I believe it was Mr. McBride that decided to go ahead and do that.
Okay, and have the adult child be interviewed?
Yes.
So it's your understanding that Mr. McBride advised SBI to do that interview?
That's my understanding.
Understood. Okay. You also testified on January 16th that you weren't really sure whether your office had a written policy for how to deal with either actual conflicts of interest or the appearance of conflicts of interest.
Yeah, I assume that they did, but I couldn't point to one at that time.
Okay. And then after the hearing, did you locate a written policy?
I did.
Okay. And at the time that you were discussing with the prosecutor whose adult child we're talking about, the fact that that child had been at UVU on September 10th and had witnessed many of the events surrounding Mr. Kirk's death, did you actually consult that written policy back in October?
No, but I followed it.
Had you previously read it?
I'm sure I had at some point. I mean, it's a pretty standard policy. If there's a conflict within the office, then, or a potential conflict, then the attorney will notify us, we'll review it and decide whether any action is needed, if at all.
Okay, but when
that's what we did.
When I asked you on January 16th, is there a written policy? Your answer was, I'm not sure.
Right.
There was a subpoena for documents that you received and complied with over the last week or so, correct?
Yes.
Okay. And one of the things that we asked for in that subpoena was any memoranda or writings that memorialized how your office handled the potential conflict of interest.
As I understood the subpoena, it's any discussions regarding whether or not there is a conflict.
Right.
And so, yeah.
And so what I take from the return on the subpoena, if I could call it that, is that there isn't any memo to the file. There's no legal analysis. There's no memorialization of the decision that you made that there's neither an actual conflict or an appearance of a conflict.
No, there's not.
You mentioned when you were testifying at the last hearing that you are the president-elect of SWAP. Could you just remind the court what SWAP is?
SWAP is a statewide association of public prosecutors or public attorneys and prosecutors. It's basically a lobbying group with respect to legislative matters that affect prosecution.
And how long have you been a member of SWAP?
For about
As long as you can remember?
the 3 years that I've been county attorney, I've been a member, a board member of SWAP.
Okay. And are you familiar with a document that they produced called Utah Prosecutors Best Practices?
I know that they have that document, yes.
Did you consult that document with respect to what your office should do in connection with the potential conflict of interest or the appearance of a conflict of interest that we're discussing?
I don't believe I consulted it. I relied on my 25 years of knowledge of conflicts and so forth.
Your Honor, what I would like to do, if I may, is approach Mr. Gray with a document that I'm just going to mark for identification as Exhibit I, and that's because we've previously marked for identification A through H, if I have my alphabet correct.
Yes.
And if I may pass one up to the court, I will, if the court needs that.
No, feel free to approach Mr. Gray and present
All right,
Exhibit
thank
I.
you. Gray, I'm handing you something that's been marked as Exhibit I for identification only. Oh, I'm sorry, of course. Have you seen this document before?
I've seen it, yes.
All right.
I mean, there's a lot more than just conflict in our best practices.
Absolutely, but we're just
Yeah.
going to talk about that, okay?
Yeah.
All right, so what I'd like to do is turn your attention to page 2 of that document, which has a whole section addressing conflicts of interest. Would you agree with me that it starts in the middle of page 2?
Yes.
All right. And you see what I'll refer to as General Standard 1.30, conflict avoidance.
Yes.
All right, could you just read that aloud for the record, please?
A prosecutor should not hold an interest or engage in activities that conflict, have a significant potential to conflict, or are likely to create a reasonable appearance of conflict with the duties and responsibilities of the prosecutor's office.
All right. What do you take to mean a reasonable appearance of conflict?
There has to be a real actual conflict, that there could be actually an appearance of that conflict.
And that would be in the views of the public, right?
That would be based on Supreme Court case law and case law generally.
But it's an appearance. What I'm asking you is, would you agree with me that there's an appearance to the public?
Objection. This causes for a legal conclusion, Your Honor.
Witness,
Mr. Novak.
well, the witness testified that he's been aware of conflict principles for 25 years. So I think he should respond to that question.
I think this is a good argument to have with the court after the evidence has been presented, whether or not there's an appearance of a conflict, what that means. But I don't think the witness's opinion about it is evidence.
Thank you. I'm going to sustain the objection. Mr. Novak.
Understood. Mr. Gray, why don't you turn to page 3, and that would be standard toward the bottom. (1-3.3C). Do you see that?
Yes.
Okay, could you read 1-3.3C aloud for the record?
If a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal.
All right, Mr. Gray, I want to ask you some questions about the decision to file a notice of intent to seek the death penalty against Mr. Robinson and the fact, which is beyond dispute, that a adult child of a member of the prosecution team was present at the shooting of Mr. Kirk, all right? You state in your opposition, well, let me back up. You testified on January 16th that you are the one who drafted the opposition to the motion to disqualify, correct?
Yes.
All right. So even though there's no affidavit by you, you stand by the contents?
Yeah, I said to the extent that we could either proffer that information or testify, and here I am.
Okay. So my first question is there a formal written policy or guidelines or procedure, I don't want you to get hung up on my nouns, for when your office decides to seek or not seek the death penalty in a case?
Anytime that it's an aggravated murder case, there's a potential for that.
Okay, so I understand that because that's what the statute says.
That's right.
But my question is there a policy, a procedure, a protocol, something in writing?
No,
Okay, and is it your view that it's your decision alone because you're the elected county attorney?
yes,
Okay, and in this case, did you discuss that question, whether the state should seek the death penalty, with your team before that decision was made?
yes,
And did that conversation include the adult prosecutor whose child is the adult student at UVU we're talking about?
no.
Are you saying that that prosecutor was specifically excluded?
No, maybe I misunderstood your question.
Okay.
I thought you asked whether or not we discussed her status as a witness.
Let me back
there.
up, because it was a bad question if you didn't understand it.
Okay.
Those are the rules, right? Okay. So you discussed with your prosecution team whether or not the state would seek the death penalty against
Yes,
whoever the state accused of committing that crime.
yes.
All right. And
I should back up. I mean, I don't know that we had a discussion before they actually had an arrest. I mean, that was 2 days later, but certainly in between the time that we filed and then we did have a discussion.
okay, so what you're saying, if I'm not trying to put words in your mouth, but just so the record is clear, is that after Mr. Robinson was arrested, your team had a conversation about whether or not it would file a notice of intent to seek the death penalty.
It was rather informal. I don't know that we all got together and said, what are we going to do? I would talk to different members of my team. But I had pretty much made up my decision. And so they knew where I was going.
Did you make up your decision before there was an arrest?
I thought that based on if we had the evidence that, yeah, we would be seeking the death penalty.
And you were already aware at that time that the child of one of your team members was present at that event, right?
Sure.
All right. Now, what you're saying is that and that you discussed that with all of the team members, even if informally.
As far as the death penalty?
Yes.
Yes.
Okay. And you didn't exclude from that
No.
conversation the prosecutor whose child we're talking
No.
about. That prosecutor was included in the conversation
Yes.
about whether to seek the death penalty.
Yes.
All right. And you're aware, because I think you were present, that there were a number of press conferences held by elected state officials both before and after Mr. Robinson's arrest, correct?
Yes.
Okay. The governor, who's a former licensed attorney in Utah, held a press conference on September 10th. Were you present there?
Probably. I was president at two different press conferences.
So there was one on the 10th and one on the 11th.
I know he made other statements as well, so I'm not quite certain. I know that I was at two different press conferences.
So when Governor Cox announced at a press conference that the state was going to seek the death penalty, had you already told Governor Cox that that was your decision?
I believe his statements, the only thing that I can remember of his statements is he said, by the way, or something to that effect, Utah has the death penalty. And so that's the one statement that I'm aware of. I mean, it wasn't exactly a demand for the death penalty, but so, I mean, the death penalty, ultimately, I made my final decision by the time filed charges, if that's.
Okay, but the question I asked you was, had you discussed with the governor your intentions?
At some point, I did. I told the governor that I intended to seek the death penalty.
And was that before Mr. Robinson was arrested?
I don't recall if it was before or after.
Okay, I'm going to represent to you, and we can file an exhibit on this in a bit, that on September 11th, the governor said at that second press conference, we are working with our attorneys, getting affidavits so we can pursue the death penalty in this case, and that will happen. And you were standing next to him when he said that, right?
I probably was.
Okay. Had you already told him that you've discussed this with your team and this is our decision?
I may have. I remember telling him that I would be seeking the death penalty.
Did you tell the governor that the child of one of the members of your office was present at the shooting?
No.
Did you tell anybody else in state government that the child of one of the members of your team was at the rally?
Not that I can recall. It just wasn't part of my thinking.
Okay. Are you aware whether the member of your team told the governor or anybody in state government about that?
I don't know. Certainly not when I was in the room with them that I can recall.
Now I'm going to ask you the same questions about federal officials. Did you inform any federal officials that one of your prosecution team members, a senior member of your office, had a child who was there at the time of the shooting?
No.
Did you tell anybody in federal government or federal law enforcement that you were going to be seeking the death penalty before Mr. Robinson was elected? I'm sorry, before Mr. Robinson was arrested?
I mean, when I talked to the governor, Kash Patel and Dan Bongino were there as well, so they heard my statement that that's what I intended to do.
Okay. And were you aware that before you filed that notice, the President of the United States went on national television and said, I hope he gets the death penalty?
I had heard that he said that, yes.
That was before you filed the notice?
Yes.
All right. Now, you stated in your briefing that your decision to file the death penalty notice when you did was partly because you ran for elected office 3 years earlier on a commitment to seek the death penalty.
Yes.
So you made a commitment. Sometimes we call that a campaign promise. I'm not trying to make light of it, but that is what we frequently call commitments that we make to the voters, right?
It was a commitment that I would seek the death penalty in all appropriate cases.
And you knew before you filed the notice But the governor thought it was an appropriate case,
Yeah,
and the president thought it was an appropriate case.
yeah.
Did Mr. Patel express his views?
Not that I recall. I mean, he was doing the bidding of the president, so. But I did find it a little interesting, Governor Cox, because he plays no part in the decision. So,
Did you tell Governor Cox after he made those public statements, this is not your decision, this is my decision?
no.
Was it important to you that the people you selected to be on the team for this prosecution remain on the team? I mean, you handpicked this team, right?
I did handpick this team.
Right. And the person whose child we're talking about is a long-standing, experienced senior member of your office,
Yes.
right?
Yes.
It was important for you that they be part of this case.
I want the best people on my team, and I believe I chose the best people.
May I have a moment?
Of course.
Thank you, Your Honor. We have no further questions for Mr. Gray. And if I may, what he told me is that he, after the examination, I assume that there's some cross-examination, he'll be available to be on call, so we don't need the court to address that with him, but he's going to leave the building, which is fine with us.
Yeah, but I'll be available to come back if needed.
Thank you, Mr. Gary. Thank you, Mr. Novak.
Thank you. And I'd just like the record to reflect that it's 5 minutes after 2 when I've concluded my direct.
I appreciate that.
Not yet. Not yet.
To the state, Mr. McBride.
I'm going to refer to the prosecutor in your office whose child was present at the shooting as Prosecutor A. Do you know who I'm talking about?
Yes.
Have you ever met Prosecutor A's child that was present at that shooting?
Not that I could remember. I could have in passing, but not that I can remember.
Did the presence of Prosecutor A's child have any effect on the decisions you've made in this case?
Zero.
Did that child's presence have any effect on your decision to seek the death penalty?
Zero.
Why did you choose to seek the death penalty in this case?
Because the evidence that had been gathered supports the aggravated murder charge, and I believe that the death penalty is entirely appropriate in this particular case.
On September 10th, you've testified that you learned that Prosecutor A's child was present at the shooting, correct?
Yes.
Did her presence affect the decisions you made on September 10th at all?
No.
Will you describe how her presence affected your decision-making on that day and in the few days following before you charged?
It had no effect whatsoever. I mean, quite frankly, as I think I testified earlier, I didn't even give it a second thought after I was told about that.
There's been some question about the reason you chose to seek the death penalty at the time you did. Now, the law in Utah allows you to wait to announce the decision to seek the death penalty until after arraignment, correct?
Yes.
Why did you give the notice of intent to seek the death penalty at the time you did rather than waiting?
I had learned from experience in a prior case, in particular, the Michael Jane case, that in a highly publicized case, the longer that you delay that decision, even though, I mean, I may very well make the decision early on, and I have in certain cases, but the more delay, then it just creates all this unnecessary public speculation and everything else. And we actually, in the Michael Jane case, I went to my attorneys and they said, yeah, we usually wait. But so I was waiting, but then Channel 2, I believe it was, contacted me and said that they had learned information that we were taking the death penalty off of that case. And so I had to hurry and call them before that say that's not true, and within a month I filed the death penalty. But it creates unnecessary angst with families of victims. I knew that this particular case was, talk about publicity, it's even more so in this case than it was in Michael Jane case. And I wanted to shut that out so that we didn't have to deal with that, and so that Erica Kirk didn't have to deal with that uncertainty.
Okay, as you made the decision in this, so that's the reason you made the decision at the time you did. Is
Yes.
that right?
Yeah.
To avoid that uncertainty, speculation, and so forth.
Yes.
Was that decision made because Prosecutor A's child was present at the event?
No.
You talked about a campaign promise. When did you run for county attorney and make that campaign commitment to voters that you would seek the death penalty in appropriate cases?
It was
What year?
it was about 4 years from this very time.
Okay.
So
At that time, did you know Prosecutor A?
I knew of him, but because I had handled
Had you met him personally and interacted with him personally? Or
no.
you just knew who he was?
Yeah.
Okay.
At some point after I won the election, I met with him and others to determine who.
Understood. But at that time, when you were making that campaign commitment, was it because you knew Prosecutor A?
No.
Okay. Was it because Prosecutor A had an adult child?
No.
Okay. Decision-making. As far as the decision-making in this case goes, who makes the ultimate decisions on major decisions in this case?
I do.
Does Prosecutor A, does the buck stop with Prosecutor A?
No.
There's been some evidence that deputy county attorneys in your office went to the command center at Utah Valley University on September 10th and the days after that.
Yes.
Is that a normal process?
Yes. In any homicide case or big case, we'll have attorneys respond to the command post to offer any assistance that may be needed, which may include search warrants or discussions about, the need for certain evidence.
So having attorneys appear at Utah Valley University that day was not unusual?
How many?
My question is, having attorneys appear at the court.
Not unusual at all.
Do you know which attorneys went?
Yes. I know that I went, Mr. Grunander went, you went, Ryan McBride, and David Sturgill went. And I don't believe any others. Somebody else may have gone there for a short period of time, but I don't recall seeing them there.
Did those attorneys go there because Prosecutor A's child was present?
Not to my knowledge, no.
Aside from charging, have many major decisions, aside from charging and the notice of seeking the death penalty in this case, have many major decisions been made in this case?
Major decisions, no. What comes to my mind is one major decision was to make sure that defense counsel gets discovery in a timely manner. That was, quite frankly, foremost on my mind once we filed the case. And I personally directed procedures to be put in place so that there would be no mistake as to what the defense counsel received and what we had. Every time there's a motion, obviously the team is working on it. We work on it together. But as far as trial strategies or things like that, none of those decisions have been made.
Is it fair to say that aside from charging and the death penalty decision, Is it fair to say that the most important decisions are yet to be made in this case?
Yes,
And that includes trial strategy,
yes,
preliminary hearing strategy,
yes,
any plea negotiation.
yes.
In all the decisions that have been made up to date, has Prosecutor A's child come up in those decisions?
No. Not
I
that
should say,
can
aside from this motion.
recall. Aside from this motion, yeah.
And so aside from this, I'm going to ask that question again to make sure the record is clear. Aside from this motion to disqualify the Utah County Attorney's Office, has Prosecutor A's child come up in any of the decisions made in this case?
No.
Has Prosecutor A's involvement in this as a witness here affected the prosecution in any way in this case, in your opinion and observation?
No.
Do you believe it will affect the prosecution in the future?
No.
Why not?
Because this is somebody that happened to be there. That has, what we're concerned about is the evidence supporting the charges. That's first and foremost. And that has nothing to do with somebody that happened to be there. Quite frankly, completely irrelevant to anything that matters in the case.
Okay. A couple other follow-ups. Earlier, you testified that Prosecutor A received you were with Prosecutor A when Prosecutor A received a message from his child that Charlie Kirk had been shot.
Yes.
Is that right? And then you testified that Prosecutor A left to go to the scene. Do you know why Prosecutor A left? Was it to go to the scene and help law enforcement or to be with his child?
To assist in any way we can with law enforcement.
You previously testified that you did not consult the Attorney General's office about whether or not this was a conflict of interest that would require your office to leave the case or to refer the case. Why did you not consult the Attorney General's office?
Because what they would have done is, researched it and then come back. And I've done that for, over 30 years in my practice. I'm capable of doing that.
Researched it where?
Case law and so forth. Again, I do not believe that there's any conflict whatsoever. I made that conclusion. I stand by that. Out of an abundance of caution, we certainly notified counsel out of an abundance of caution. And I think that's the appropriate action to take. Again, I understand what the concern about conflict is whether or not it has any possibility of affecting your decision-making as a prosecutor. And I didn't see how this does in any way.
Okay, if I can have just a moment. You said you had some neighbors that had children that attended the event where Mr. Kirk was shot.
I was told that they were there, yeah.
When did you learn that those people were there?
I don't know, a couple weeks after, I believe, after the event.
After the charging decision was made?
Yes.
How closely do you know the children that were there?
Not well at all.
Okay.
Maybe a hello or something out on occasion. But as far as I know, I'm not even sure that they even live in our ward at all at this point.
Okay. Thank you.
All right. Mr. Novak.
No, thank you, Your Honor. I don't have any redirect at this time.
As previously discussed, may Mr. Gray be excused.
For now, yes.
Thank you. Thank you, Mr. Director. Mr. Novak, your next witness? Or I'm sorry, Ms. Nestor. Your next
Your Honor,
witness.
at this time, we were going to call the adult child, but I believe that that individual's attorney, they're ready? Okay, then they are ready. So we would like to proceed with calling the adult child at this point. I think it would be appropriate to hear whether or not we close the hearing or at least come up with some ground rules about preventing any photography or mentioning of her name, however the court desires to handle it.
Thank you. I'll hear briefly from the parties. I did read the proffer of facts regarding the closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office, and I'll hear any additional argument or statements prior to making a ruling.
Your Honor, Ryan McBride for the state. We do move to close the hearing for the testimony of the adult child. I think the rationale that I explained previously still stands. The rules of judicial administration allow closure for privacy and safety reasons. I believe with the proffer of facts that the defense has accepted here, we have shown that there are privacy and safety reasons that favor closing the hearing. Defense counsel has stipulated a closure of this portion of the hearing. The media in the past has stipulated to closure of the hearing. I think the record is adequate. I think the safety concerns support closure. And absent any questions from the court, I would make that motion now.
Thank you. Anything further from the parties?
No objection, Your Honor.
All right, so the prosecution cited to the media. Did you want to weigh in?
He does not object to the closure of this portion.
Thank you. The court has reviewed the parties' prior arguments and materials submitted in advance of today's hearing, including the filing entitled Proffer of Facts Regarding Closure of Portions of the Evidentiary Hearing on the Motion to Disqualify the Utah County Attorney's Office. The defense has requested that the testimony of certain witnesses, specifically Prosecutor A, an adult child witness, be received in a closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and maintain confidence in the judicial process. This court must also be mindful of the constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erica Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult child witness is called to testify, which is the request at this point, the court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witness's testimony in closed session is partially denied. The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent judicial proceedings. Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information. Once that limited portion of the proceeding is complete, the courtroom will be reopened and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed and no photographs of the witness will be taken. At the conclusion of the adult child witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the proceedings. The court finds that this procedure is narrowly tailored, uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief, we will go ahead and clear the courtroom and go into a closed session. And the only remaining parties will be the attorneys, and we will take it from that point. Court will be in brief recess for 2 minutes.
All rise. Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.